With this capital murder prosecution still open and the state is not, they're officially at this point still seeking our client's death. We have to defend that. And it won't be a 3-day hearing, I don't think, Judge. But that's the way the state has elected to proceed. We'll do what the
Gerald Burke is your attorney, but his partner is here today. And please, for the presentation and introduction on behalf of Mr. Turner, if you would be, please tell us your full name and the firm you were associated with, sir. Thank you.
I'm Robert Loper, Loper, and I'm the owner of Loper Law in Houston, Texas.
And welcome.
Thank you.
I went to law school with Don Loper. I don't know if he didn't ever do any criminal work.
He didn't, and I know who Don is because our name is spelled very similarly. He has 2 O's, I have 1 O.
Oh, was that right?
But I knew him as far back as law school as well.
Okay, yeah, the University of Houston. We went to school together. Smart guy. And Mr. Coleman is here on behalf of the district attorney's office. What are we going to be doing today here?
Your Honor, the state would prefer to proceed on the MTRP. I don't know if the court's inclined to get pleas of true or not true as to the allegations, but that would be the state's preference, Your Honor.
What do y'all?
What I understood we were coming for today was for the state to tell the court, and I think he just did, whether they wanted to proceed to a trial setting in the capital case or whether they wanted to proceed on their motion to adjudicate. Now, he served us weeks and weeks ago with the First Amendment motion, so we have that in hand. And he has told me this afternoon that that's what they plan to do and proceed to that hearing.
All right. Is this something he's agreeing to, or is this a contested hearing?
It's going to be contested.
Oh, okay. Did y'all want to do it today?
Oh, no, Judge.
Oh.
Not at all. I thought at most today we may get pleas of true or not true, but of course it's at the court's pleasure.
All right. Well, let's see where that goes. And cause number 21-36929, the state of Texas versus Javonte Turner. The first amended motion to revoke unadjudicated probation is pending in this case. This was stand by. When was this file? I don't see a file stamp on it. Do we have a date that this was filed?
Not often, Judge.
I'm looking now electronic also.
It's kind of odd. Yeah, I mean, it's
Judge, I'm showing August the 18th of this year, Judge. That's much.
okay. Yeah, there's nothing on there. Generally, there's something on these motions that are file stamped of when they're filed.
I actually have a file stamp copy.
You do? That makes one of us.
I have to share it.
It's in the electronic file. We must just put a copy in your file before we electronically.
Okay, this was filed on 8/18/25. It looks like.
That's my understanding.
Yes, sir. I have an order that is purportedly signed by me, but it's one of these automatic orders that on August 19th of 2025 came on to be heard on behalf of the state of Texas by the Assistant Criminal District Attorney, a request that a hearing on this to adjudicate the first amended motion to revoke probation be held. And so I signed it, and then it was set for today, I guess, for an announcement. So this first amended motion to revoke unadjudicated probation. And just raise your right hand, sir. Do you solemnly swear or affirm that any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. You don't even have to make a statement, but if you do, it's under oath. In summary, this first amended motion to revoke unadjudicated probation states that on September 13th, 2021, you were placed on 10 years deferred or unadjudicated probation for the first degree felony of aggravated robbery. Is that true? Okay. Then there are several allegations of violations.
Your Honor,
Do we need to go through these
And
or?
we can save some time and
All right.
enter a universal plea of not true at this time
Okay.
until such time as we have a hearing on the
All right.
merits.
and Your Honor, if I may, the state will opt to abandon paragraph 1, the allegation regarding the murder. However, we will reserve our right to put on evidence as an extraneous offense at a later date, Judge.
All right. Any
Without
objection?
objection, Judge.
All right, that allegation is moved to be abandoned from the first amended motion to revoke probation, allegation 1, but the state is reserving its right to include it if necessary in a motion to revoke probation hearing that might go toward the consideration of punishment.
Precisely, Judge.
All right, and then you've got allegations 2 through 20 that your attorney has probably reviewed with you, and pleas of untrue will be entered on your behalf on those. All right, what do we do next?
If I could address a small fumble of the ball on the defense team. In September, we picked up a hard drive that had all of the evidence. We even had some discussion at the last setting about some discovery that was missing at the time. And so the state put that together. I came over in person and picked it up. We brought it back to Houston. I handed it to our third lawyer, Mandy Miller, who was going to get it to an expert to take a look at. Somewhere along the way, FedEx dropped the ball and it's missing. And it's been missing for about 2+ weeks.
Yeah.
Ms. Miller is in touch with their office and was going to supply 2 additional drives that they were going to make a copy for us and a copy we could just send to the expert. I talked to Mr. Tommy about that, and they're supposed to have been delivered today. As soon as we're finished here, I'm going to go up to their office to see if Karen has those, which would help us get on the way to being prepared to have a hearing on this.
Okay. What do you want to do today then? Defer a determination of, we need to reset, at least a review in a period of time just to make sure that we're progressing. We got to set a setting of some sort. How much time henceforth for just a status review? Don't have to be here, just on that day, we'll find out what everybody wants to do. And 3 weeks are good, or 4 weeks?
At the pleasure of the court for the state judge.
If I could handpick, you don't mind, Judge, the week of the 10th, that would be good. I think my other partners will be available, at least back in country, so we can communicate, which then we can then pick the date to have the hearing.
You're talking about November?
Yes.
If I get next month? What day of the week is that?
The week of the 10th.
You do the 12th or the 13th, which is Wednesday or Thursday, or honestly, even Friday, if you want to come in on Friday.
Wednesday or Thursday is fine. We'll be doing the
Okay.
afternoon again.
Yes, sir.
Oh.
Yes, we'll do the afternoon.
Okay.
Didn't
Good.
just pick one. That's
All
what
right.
good, Judge.
Reset then? Anything else?
No, Judge, I guess at that time we can talk logistics. I mean, I had a time estimate for the hearing in total of about 3 days. Mr. Bork seemed to have had a different opinion about the length.
Judge, the capital murder indictment is still open.
Mm-hmm.
And so if the court were to find that there was sufficient evidence to revoke our client's probation, and then we go to that quote punishment hearing where the state want to present that capital case, it's like trying a capital murder trial in its entirety.
Mhm.
I think it will take a substantial amount of time to do that.
Yeah.
And
What's the
since
point?
that prosecution is still open, Judge, and the state hasn't ultimately revealed us the decision they're making on punishment in that case, it's going to cause us to spend quite a bit of time in defending the motion itself.
We got whatever's time's necessary, but you got 20 allegations here of just one necessary for revocation. This is a first degree felony of aggravated robbery. Really, is it realistic to consider putting on a capital murder case in front of the court on a motion to revoke probation?
It was not my intent to put on the entire case. I wanted to give the court a flavor, an idea.
Yes, sir.
I'll represent to the court. I'll do everything I can to truncate that process. But I think that that's relevant punishment evidence to the extent we can give the court some idea of the surrounding circumstances.
And I think that's been done before, Your Honor. Mr. Laird proved up a murder case and 3 witnesses in there. So I think we can certainly.
We're talking about a capital murder, right?
Yes, sir.
That's what we're talking
I think it
about.
can certainly be trimmed down.
Which is my intent, Judge.
I've never tried a capital murder that didn't take weeks.
Under these circumstances, in the context of an MTRP, Judge, I think we can endeavor to knock it down significantly, Judge.
Okay. But, all right.
course,
I don't want to restrict you. You're entitled to present that. It just seems with 20 allegations, and some of those are first degree felony allegations. I'm not sure what
The value
is what you're reaching for that you may not be able to gain through successfully proving other allegations, but that's,
understood, Judge.
I can understand it in maybe a different kind of setting. I mean, if you were trying the capital case, but what's our plan on that? Oh, you want to take one step at a time?
That's right, Judge. I think depending on the outcome of that MTRP, it could very well help move us along in disposing of that
And
capital murder.
and also, if the probation is revoked, then I guess certainly they're entitled to present evidence on for the purposes of what is the appropriate sentence.
Technically, Judge, we put that case on appeal, although we don't have a real right to appeal. But you're right; they still would be able to present that in the punishment stage, depending upon whether they seek death or not on the case. But that harkens me back to what I said a minute ago, which is with this capital murder prosecution still open and the state is not, they're officially at this point still seeking our client's death. We have to defend that. And it won't be a 3-day hearing, I don't think, Judge. But that's the way the state has elected to proceed. We'll do what the court.
Well, let's see what happens, but try to
I can read between the lines.
Yeah.
Judge.
do what you need to do as expeditiously as possible
Yes.
under the circumstances, and and that's y'all to figure it out and me to figure it out as well. But let's get to it and try to get a date certain with a block of time and get ready to move through that. But yeah, I'm still not sure with what you're alleging here, that I'm not sure what you are, of course, your business, but what you the first 15 allegations are
Oh, we're okay. That's it. Nothing.
allegations 6 through 15 are all substantive crimes,
Yes, sir.
which are, I believe, all felonies. And then the other it's like 16. Well, you know what they got, but I'm not sure what is gained on on proving up the capital case if unless these are not proven. But anyway, that's something y'all decide and see what strategy is done, and we'll work with you.
Yes, sir.
Thank you, Judge.
Thank you, sir.
Maybe excuse.
Yes, we're gonna